Good morning, everyone. Welcome back. This is DeRollo Nixon from Nixon Disability Law, coming to you again as part of our Veterans Month campaign, where we're bringing you important history, trivia, and helpful tips to veterans and about veterans. Veterans are important members in our community, and one of our themes in celebrating them this month is showing how they impact communities for the better, but also helping educate the community of civilians and non-veterans about the good things that veterans do, but also some of the challenges that veterans face. Today, we're continuing the subpart of our series about the relationship between Congress and veterans when we come to arguably the second most important decision Congress ever made that relates to veterans benefits. The most important decision that Congress made arguably would have been the Continental Congress deciding to provide pensions for veterans in certain circumstances. But the second most important decision was certainly the Veterans Judicial Review Act of 1988. Okay, this act was signed by President Reagan and became law in November of 1988. It solved two constitutional problems. One, it created judicial review for Veterans Administration benefits decisions, okay? And second, it provided for legal representation of veterans for that purpose. Prior to the VGRA, veterans arguably were in a wasteland. While Congress had stated that the VA benefit system was non-adversarial, and I can already hear some of you laughing because you know that that's basically an empty and a specious statement, okay? With all due respect to Congress, the system in many, many instances did not operate non-adversarially, and so veterans were routinely denied benefits. And it may shock you to realize that prior to the passing of the VGRA, once the Board of Veterans Appeals, okay, which is the highest internal organization within VA, or the Department of Veterans Affairs, as VA is now called, and VA for short. The Board of Veterans Appeals, which is the highest level to which you can take a benefits denial within VA itself, they were the last stop. The buck stopped, or so said Congress, the buck stopped with the Board of Veterans Appeals. Now, to me, that's insulting, and to add insult to injury, to add injury to insult, veterans weren't able to legally retain legal counsel or attorneys like myself to help in this process prior to the VGRA. I think both aspects are unconstitutional. I would argue that they are. There's several court cases, and I will spare you the citations, that do not agree with me, including at the level of the U.S. Supreme Court. I just think that one can, in a pretty straightforward manner, certainly to non-lawyers, make the case that such actions were unconstitutional and that they needed to be changed. And thankfully, by the VGRA, they were. Okay, first of all, does it surprise you to know that prior to the VGRA, the Veterans Administration, as VA was then called, was the sole federal agency whose decisions affecting the rights of citizens were not reviewable in federal court? And we're talking about, agencies that didn't involve, sensitive national security matters. Zero doubt in my mind that, for example, CIA can take some action internally and it not be reviewable. I get it. That's not what we're talking about. We're talking about an agency that represented and adjudicated the rights of tens of millions of Americans over several decades, okay? It is an insult. It's spitting in the face of U.S. citizens to say that any federal agency can make a decision that affects your rights and a federal court can't weigh in on it. Now, the reason for that ugly position was because of an act of Congress in 1940, which had a part of it called Section 211A that explicitly said that, the administrator's decisions on benefits matters weren't reviewable. I don't care. Just because Congress puts it in a statute, it doesn't make it constitutional. And so we would then look to the Article III courts, like a federal district court, and then ultimately to the U.S. Supreme Court to weigh in and strike such a provision down. However, they declined to. But we've been there before, right? I mean, the Dred Scott decision not only didn't strike down something, but it upheld something, right? Okay, and that's just an insult. That's an abuse of power. That's what we call that. Plessy versus Ferguson in 1896, same thing. Were they constitutional? No. A fair reading of the Constitution sees that they were merely abuses of power, okay? And that's what those decisions should be called, that purported to uphold the constitutionality of Section 211A. That's what this constitutional lawyer says, quite vehemently, as you can hear. Anyway, that's not the sole ground that I use to assert that position prior to the VGRA of 1988 was unconstitutional. Next, the Constitution itself, okay, represents a limited grant of power to the federal government from the states and the people. And as the 10th Amendment strongly indicates, and not just the 10th Amendment, there's a specific section of the Constitution that backs this up, okay, that the rights not specifically granted are retained by the states and or the people, okay? And so, first of all, it's a limited grant of power. Next, the U.S. Constitution restrains both Congress and executive agencies from operating, i.e., from making decisions that affect people's rights or taking actions that affect people's rights in a manner that denies U.S. citizens due process of law. Now, to me, the real question isn't, well, are all the veterans U.S. citizens? That, to me, is a non-issue, okay? The real issue is due process of law implicated, or was it implicated when Congress said, hey, by the way, these decisions can't be reviewed in federal court? And obviously it was implicated. If you back up to England in the 18th century, there are many actions taken by government officials over which the officials personally could be sued, okay? And if such a circumstance remained, maybe I wouldn't have a problem with the way the veterans benefits system and disputes about the veterans benefits decisions were handled. But that wasn't the case. And so to me, it was manifestly unconstitutional. Even worse for me as an attorney, okay, I've been a licensed and practicing attorney since 2006. And I've been accredited by the Department of Veterans Affairs since March of 2016 to do this work. The fact that you could not retain legal counsel is to me, it's abominable, okay? If you can retain legal counsel because someone is accusing you of horrendous crimes involving children or a school or something, then why can't you retain counsel to help you get your veterans benefits? It's absurd, okay? And yet it purported to be the law, and what this constitutional lawyer is telling y'all is that now this was an abuse of power. This wasn't really a constitutional arrangement. And so, thankfully, Congress finally saw fit to fix that with the Veterans Judicial Review Act of 1988. Thank you for listening. We appreciate it. In the next bit, I'm going to explain other aspects of the VGRA, and then we will move on, hopefully, to more helpful matters, because we will almost be done with the history portion of these podcasts and then talk more about helpful tips and things like that. Thanks so much. Stay tuned.